Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, within and for the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. Please be seated.
Okay, good morning. Madam Clerk.
SJC 13663, Commonwealth versus Karen Reed.
Attorney Weinberg.
Good morning. Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent, and we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first...
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to...
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof that a 5th juror contacted the defense. A juror who could have been one of the 5, could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the...
Just to stop there, because the judge who spoke up and said, "You're not saying that more than 5 jurors came forward, are you?" It just seemed a little scrutinizing on her part. Like, if she read the pleadings, if she read the defense's motions thus far, she would have known that at no point in any of their filings does the defense say that more than 5 jurors came forward. The defense only references the vote for count 2, right? They reference the vote for count 2. They don't even ask for the court to address count 2. They ask the court to address counts 1 and 3. They refer to count 2 as count 2 being the only count which the jury were deadlocked. So I'm just saying the judge already is, in my opinion, scrutinizing his word usage, and she seems a little impatient. Like, hear him out. And again, it was not in their pleadings. You know, I'm saying so far Martin Weinberg has been pretty clear to me, and I'm aware of all of their pleadings, all of their filings. You know, I'm clear and caught up on what they have asked this court to do. And if the judge was clear and caught up on what they asked the court to do, she would not have made that assertion. She would not have needed to ask that question.
Trial court, at which we contend the probability, if not the certainty, that voir dire would result in proof that there was a final and binding...
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous
Well,
decision.
you cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what the situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal.
Stopping it there, because if you guys remember the ACLUM amicus brief, the ACLUM provided case law referring to verdicts being read in open court, that whether or not they are read in open court, they can still be accounted for, even in post-trial inquiries. The ACLUM provided case law indicating that just because a verdict is not read in open court does not mean that the verdict cannot be considered. So I am starting to wonder if these judges even read the ACLUM amicus brief, or if they even read the defense's motions to dismiss.
And substitute a verdict because of the declaration.
Well, that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents.
So this judge, the male judge that just spoke, he just said, so do you want us to carve out a new exception to that rule? Like, he's asking Attorney Weinberg, do you want us to create new case law? Because the arguments you're presenting here are not applicable. The providing a post-trial inquiry as to verdicts, or to inquire with the jury, to ask them questions post-trial. The judge, the male judge, I don't know his name, he is saying that you can only do that in extraneous circumstances, like when there's bias or racism or what have you, controversial things occurring among the jury members. But again, the defense and the ACLUM both provided case law in which post-trial inquiries happen regularly and for far less convincing, less solid reasons. Multiple jurors came forward after the trial, after the Karen Reed trial, after it was declared a mistrial. The next day, multiple jury members came forward and contacted the defense, and then they contacted the prosecution, and then they contacted Aidan Kearney, and they were all saying that Karen Reed was acquitted on counts 1 and 3. Okay, that's convincing, clear and convincing evidence that a post-trial inquiry is necessary. Like, don't you want to hear from the jury? They reached out to the defense, they reached out to the prosecution, they reached out to Aidan Kearney. Like, why is judge after judge after judge in Massachusetts making it such a big effing deal? Like, all right, we're going to keep watching. But guys, so far, it's pissing me off. The female judge that spoke earlier, don't know her name, don't know which one it was because the camera wasn't pointed at her face, and this male judge are both already scrutinizing and unconvinced. They are seemingly unconvinced. And again, I'm not even sure they read the amicus brief from the ACLUM, and I'm not convinced they read the defense's pleadings. It's as if they're sitting here on this day and they got the info today and they didn't review it. They're just, to me, they are immediately combative, almost protecting what has already been done, almost justifying what has already been done, rather than looking to correct what's been done.
Lord talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was...
Doesn't Fiddler caution to not inquire into the, to not to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction.
So who is that guy? I don't know, but very strange, guys. Isn't it strange to you? Isn't it strange to you that he is already, this judge, this male judge, is already using the exact same argument that the prosecution used, that Judge Beverly Cannoni used, and that Canton Confidential used? We can't go into the jury deliberations. This judge and Judge Beverly Cannoni and the prosecution and mainstream media outlets have all said that we can't go into the jury deliberations, when in fact, nowhere in any of the defense's filings is the defense asking to go into the jury deliberations. They are asking about the end result of the jury deliberations. Why does it feel like someone put out a memo and judge after judge is following that memo? At no point has the defense asked to go into jury deliberations. The defense has asked to go into the results of the deliberations, to ask the question, the simple question, were there verdicts on counts 1 and 3? And if the jury says, yeah, there were, then the defense says, what were those verdicts? And then the jury says, they were this. It's that simple. We don't need to know how they got to those verdicts. We just need to know if there were verdicts.
To a voir dire jury, we don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count 1?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Judge.
You seek to impeach the written communication of the foreperson, correct?
I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges.
That is actually a really good question by this judge, as frustrating as he has been so far. He asked Attorney Weinberg if he is looking to impeach the jury notes from the foreperson. And I would have said, hell yeah, I'm looking to impeach those jury notes because they were not specific and the world needs to know which counts those jury notes applied to. They were ambiguous. They were too ambiguous, considering the fact that there were 3 charges against Karen Reed. Okay? At no point do any of the jury notes specify which count the impasse applied to. So I'm just saying, this judge asked an important question, but I understand that Attorney Weinberg is saying, no, not necessarily. We're not looking to impeach it. And if you recall reading the motions from the defense, at no point in those motions is the defense asking to have the jury notes impeached. But now I'm wondering if they should have. Now I'm wondering if that's an avenue maybe they overlooked, or maybe they chose not to seek, Interesting. Like, was that a missed argument they could have had? And what would be the implications if the defense came to the Supreme Court, the Appellate Court, and they said, you know what, those jury notes were trash. We would like those notes impeached. And we would like a post-trial inquiry to better ascertain what the results were for each count, right? Anyway, I'm sure Attorney Weinberg knows what he's doing. I'm sure David Yannetti and Alan Jackson, I'm sure they all know what they're doing. Even though it's just Attorney Weinberg here speaking, I am sure that he consulted with Alan Jackson and David Yannetti. I am sure they are all making sure. I am sure they are all on the same page as to strategy here. But I am curious about why they didn't seek to impeach the jury notes. Maybe it would come with other implications, maybe it would open up other legal pathways that they don't want opened. Interesting.
Count 2 by itself, read vertically, had multiple charges. Horizontally, there were 3 separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial, and I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words in deadlock.
There's no inkling that what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best. It's exhausted. It's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge...
Guys, what that judge just said is, wasn't there an opportunity for the defense to speak up after the mistrial was declared when the scheduling hearing was held? And guess who else made that argument? Judge Beverly Cannoni. Judge Beverly Cannoni made that exact argument in her court filing. She claimed that the defense had an opportunity to speak up about the mistrial after the mistrial was declared during a scheduling conference. They could have spoken up about the mistrial after she declared a mistrial. Why? Like she would just overturn her own decision after she declared a mistrial in the scheduling conference? How does that make sense? Like, if it was that easy, guys, if it was that easy, then why didn't she just give the defense the dismissal they asked for? What does it matter if it's after the trial anyway? Whether the defense asked for it during the scheduling conference or they asked for it a month later, after they get all their ducks in a row, all their facts straight, after they get the jury affidavits, the jury statements, and the affidavits from the attorneys. Like, I'm just saying, guys, like, if that was truly possible, if that was truly an option, then, and Judge Bev would have been fine with it, right? Because that's what this judge is implying. And so too was Judge Bev implying the same. Both of these judges are implying that the defense had an opportunity to speak up about the mistrial during the scheduling conference, after the mistrial was declared. And I'm like, but this is still after the mistrial was declared. And the defense filed their motion through the Superior Court with Judge Beverly Cannoni, and she denied their motion. I'm just saying, guys, like, it's so peculiar to me that this judge, this guy, keeps speaking up, and when he speaks up, it's almost in defense of Judge Beverly Cannoni's arguments. And I am saying that if Judge Bev truly meant that, if she isn't lying out of her ass, and if she's implying that if the defense spoke up during the scheduling conference, that she would have considered what they had to say about the declaration of the mistrial, if that's true, then what's the big deal about not listening to them now? Like what's the big deal of giving them an opportunity now? What is it? Is it snooze you lose? Like, you should have asked me during the scheduling conference? You know, Judge Bev, in her court filings, she makes it seem like the defense had multiple opportunities to speak up before the declaration of the mistrial, which is not true. And then she even says they had an opportunity to speak up after the declaration of the mistrial, which seems to me, it's like that's a non-solution. Like, why does the defense have to correct this when it was actually Judge Beverly Cannoni's fuck up and the prosecution's fuck up? The declaration of the mistrial, again, falls solely on the prosecution and Judge Bev. They fucked up, but now it's up to the defense to fix it. And all right, we're going to keep watching. But guys, this judge just said exactly what Judge Beverly Cannoni said in her own filing.
Charged the jury. Once the judge thanked them and said the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Como versus Enid Brown, where the jury goofed, essentially? There was a miscommunication between the clerk and, you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that signed that, or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge...
I guess the point I'm asking Mr. Weinberg is, there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may...
Finally! Did you hear that? I get your point that it was hasty to not consult with the attorneys before bringing the jury back in. Finally, he throws us a bone.
After the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a scheduling conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, This is what should happen. These are my thoughts.
There was an opportunity, but not a responsibility. The law in this case, starting 39 years ago with Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were three things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question. It has no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were two ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes two previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given.
Yes.
I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between.
This is combative, if you didn't notice. This is combative on her part, and I'm not sure if she's the same female judge that spoke up earlier because the camera wasn't facing her. But I'm just going to guess that it's the same one. And if you guys ever watched the documentary Making a Murderer, they brought that case all the way to the Appellate Court. And then a higher court. And there were multiple judges, some of whom were combative. And it's as if they had preconceived ideas about the defendant in Making a Murderer, about Stephen Avery and his nephew. Like, just comparing the two guys, when an appellate court talks like this, it's as if they've already made up their minds. It's as if they are judging what the defense is doing as opposed to what the fucking judge did. Like, the whole reason we're here is because of Judge Beverly Cannoni. She didn't follow Rule 27B. She didn't follow the prerequisites for declaring a mistrial. She didn't inquire with the attorneys before she declared a mistrial. Even a judge on this stand, a judge in this room, said that. It was hasty. But the way this female judge is sounding is like the whole question, I'm sure you made that in good faith. It's she's not genuinely asking that question. It's as if she's saying, and you had better made that in good faith. To me, she's implying that he made that decision in bad faith. And if you guys don't know, good faith and bad faith in the legal system, in court language, it just pertains to intention. Were you being malicious when you did this? Bad faith? Or were you being correct, right? Were you doing the right thing? Good faith. So she's actually asking almost a rhetorical question to Attorney Weinberg, but the rhetorical question also implies that could Attorney Weinberg have made that decision maliciously. I don't like her approach. How are you going to have this approach the first time you hear oral arguments from the defense team? How are you going to have this approach immediately? And the same with the other male judge. It's not a coincidence that that male judge had the same argument Judge Beverly Cannoni had in her filings. It's like, whose filings are these judges reading? And whose filings are they prioritizing? Are they believing more than the other? It's not good already. It wasn't good for Stephen Avery in the Making a Murderer documentary. And I'm telling you, it's not good for Karen Reed. When the judges are already sounding like this, a mere minutes into the oral arguments, it tells me they already made up their minds.
That second note and the third note.
I would respectfully suggest that when a defense lawyer asks...
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note and the third note.
Yes.
That would indicate any less of an impasse between the first, second, and third notes.
Yes, what happened is that...
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a Toohey instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all three notes are ambiguous.
She is saying, if you don't know, she is saying that the defense had an opportunity to speak up after the first note. She is saying the defense had an opportunity to speak up after the second note. And they had an opportunity to speak up after the third note. And she is saying, well, if the conclusions were made after the first note that they were at an impasse, and then after the second note that they were at an impasse, and then the third note they were at an impasse, why didn't you guys object at any point after those notes? Again, what is she doing, guys? What is she doing? She is putting the onus on the defense when in fact it was Judge Beverly Cannoni's complete and total obligation to follow the rules of criminal procedure, Rule 27B specifically, because there were multiple counts against Karen Reed. Here is yet another judge putting the onus on the defense to follow the rules, to object, to predict that Judge Beverly Cannoni was going to declare a mistrial. Isn't that great, guys, that we have judges in the appellate court like this?
The defense...
That was not the argument you made below.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there was no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was that there was an ambiguity.
Not at the motion to dismiss, at the time.
They had no opportunity at the time.
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a request.
Was there any ambiguity argument made in response to the second note?
There was a request for Toohey. But the only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there's no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was...
I still don't like this, guys. I still don't like this. I don't like that they are scrutinizing what the defense could have done rather than looking at what Judge Beverly Cannoni did do. Like what ultimately matters here, people? What's the big fucking picture here? And I'm sorry if I'm yelling in your ear. Like, what is the big picture here? It's where are we right now? We have jury members who have had verdicts that they were not permitted to announce. They didn't know that they could have provided partial verdicts, right? That's where we are at. We have jury members whom have come forward and said that Karen Reed was found not guilty of counts 1 and 3. That's the big fucking picture. And why were not those verdicts announced in open court? Because Judge Beverly Cannoni did not follow Rule 27B. That is why. If she had simply followed that one rule, we would have known that Karen Reed was not guilty of counts 1 and 3 before Judge Bev declared a mistrial, like the rule instructs her to do. But look at this judge, look at these other judges, all scrutinizing the defense team, all continuing to put the onus on the defense team. It's as if they are all implying that the defense was fucking around. Like, why didn't you do it then? Why are you here today, defense team? Why are you wasting our time? You could have spoken up then. You had multiple times to speak up then. What is this? Like, do you see how suspicious they are of the defense team, questioning what the defense did during trial, when in fact this entire case is on the prosecution and the judge? The defense's only job is to protect Karen Reed. That's their fucking job, is to protect Karen Reed and to follow the rules as much as possible. To me, the only point of going back into and asking what the defense did during trial, that only serves the point to scrutinize them, to put this on them, to put the onus on them and say, we are here today because of you, defense team.
To apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's notes...
At the moment of the declaration of the mistrial, what suggested in the notes, the 3 notes, that there was any agreement as to any of the 3 charges?
Facially, they said they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note, where again, they report that they're in an impasse, quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez, and she considers that alternative and gives the Tui Rodriguez instruction.
It is not. The Tui Rodriguez is not an alternative. Did you guys just hear this appellate court judge use the word alternative, referring to the Tui Rodriguez instruction? That is not an alternative to a mistrial. It is an instruction. It is a propellant. It's a pusher. It's supposed to push the jury to make a decision, to come to a decision. It is not an alternative to a mistrial.
Now we have the third note. We've really tried on all the charges. Some of us agree that beyond a reasonable doubt, the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of...
Wow. She, right there, guys, right there. This judge has sided with Judge Bev right there.
The perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for
So
one.
your rule would be that anytime there's more than 1 charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3? That's the rule?
When there's a multiple count indictment, that's...
Yeah. What is this? Who is this judge? I hope she's watching this. I hope she can hear me. I hope her ear's ringing right now. Because how are you going to be an appellate court judge, a Supreme Court judge, and not know Rule 27B? The judge may declare a mistrial, but she must first require the jury to tell her the verdicts that they did agree on. The judge may declare a mistrial, but she must first mandate that the jury tell her the verdicts that they did agree on. How is this judge an appellate court judge? How is this judge asking this question in this manner, with this fervor? Like, so you're saying that if the jury is at an impasse, the judge has to ask them which count they're at an impasse for? Yeah, Judge, that's Rule 27B. Holy shit.
It's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
I thought it was a may, Mr. Weinberg.
The may was in the rule, the reporter's...
May declare a mistrial, but she must first. Hello, lawyers on the stand, lawyers who are posing as judges for a Supreme Court in Massachusetts. Hello, may declare a mistrial, as in she has the permission to declare a mistrial, but she must first require that the jury give her verdicts. It gives her permission to declare a mistrial, but not before she requires the jury to give her verdicts that they did agree on. Who are these judges?
Note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
In the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples, but 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. And here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go and the notes that there's an agreement, or at least partial agreement, on a particular verdict, correct?
Yes, those notes were subject to one of two interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-TUI of seeing whether the jury wanted to deliberate on any one of the three counts, which is part of the statute, I think it's 268-34C. That's a third alternative. Here the problem is the record doesn't reflect the trial judge's consideration.
As a matter of
these
fact, were there
alternatives.
3 separate verdict forms?
There was actually more than 3 verdict forms because the verdicts on count 2 had multiple, they had 3 different options.
Count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, the judge says she can't ask the questions that you're saying she could without interjecting herself in deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
Why? How would she do this? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what you're...
This is a terrible fucking question. What is he doing? What is he doing but defending Judge Bev? What is he doing but saying, but saving her ass? Like, it's as if he's saying, like, Judge Bev had a perfectly reasonable argument here that she can't really ask the jury the simple question you're asking her to ask them without her inevitably going into the jury deliberations. So what do you say, Martin Weinberg? Like, can you tell me how she can ask them that simple question without going into the jury deliberations? Like, what is this? But it's like, I can't help but feel like they're trying to save her ass. They're trying to make it seem like she's being perfectly reasonable when in fact she is not. She is not. She and the prosecution, Judge Beverly Cannoni and the prosecution are conflating. They're conflating jury deliberations with verdicts. As I've said in previous videos, they're conflating the process with the result. There are the deliberations, which is the process, and then there's the verdicts, which are the result of the process. Jury deliberations is one thing. The result of the jury deliberations is another thing. And you can ask the question that completely excludes the jury deliberations. It's that simple. What? Oh God, I can't do this. I can't with these people.
Thought processes on that.
My thought process one is that this court has the option of essentially informing the court what questions could be asked, and 2, if we're going to delegate,
require follow-up questions. And unlike extraneous influences, where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect, this is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations, inevitably?
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation, but I want to ask you the following questions. 1, did you take a vote on count 1? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that the jury can change its mind, right?
But
isn't that going to result in asking that type of question? When you say final, if you don't get your way on 2, is it final?
Was it ever reconsidered? My contention, based on these jury declarations, based on the voice.
It should just be, on the day that Judge Beverly Cannoni declared a mistrial, what was your verdict on count 1? Cool. What was your verdict on count 2? Cool. What was your verdict on count 3? Boom. That's it. The only thing that matters is what their verdicts were the day that Judge Bev declared that mistrial. Before she declared a mistrial, what were their verdicts? And again, it's up to the defense to make this determination because Judge Beverly Cannoni did not do her job.
Mayo, based on the fact that in this highly publicized case, no other juror who they served for months says to anybody, to the court, to the clerk, to the court officers, to the prosecutor, I didn't agree.
They also don't write in saying we agree with the other 5 or anything to that effect. They're silent, as their deliberations are supposed to be silent, right? See?
But it's an almost unprecedented.
So it does look like Alan Jackson and David Yannetti are there, but they're sitting in the back.
Meeting of a burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel it.
And Karen Reed is sitting with her mother in the audience.
Jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what Juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, "Hey, me too. We believe the same thing." For the court to say that this is what it meant for all time.
My guy, the jury reached out to the defense. The jury reached out to the prosecution. The jury reached out to Aidan Kearney. And not all members of the jury, but 5 members of the jury. 4 indirectly and 1 directly for the defense. The prosecution received phone calls and emails. Okay, guys? Like, my guy, where are you? Did you read the court filing? The jury members. There were affidavits. There were affidavits provided by the defense team. Those affidavits are prerequisites. They are what the defense needs to have a post-trial inquiry, asking the jury what their verdicts were. The affidavits. Like the jury members came forward and said that they were unanimous on counts 1 and 3. The deliberations concluded for counts 1 and 3. And this judge would know that if he read the filings, if he read the filings from the prosecution as well. The fact that Judge Beverly Cannoni herself in her own court filing considers those verdicts true and accurate. Oh my gosh, like Judge Beverly Cannoni herself does not argue that those verdicts happened. She just says she can't do anything about those verdicts because they weren't announced in open court, conveniently, because of her ass, because she didn't follow Rule 27B, right? She doesn't want to take any responsibility for what happened, guys, but she does consider that there were verdicts on counts 1 and 3, and those verdicts were true and accurate. Yep. It's just too much, guys. It's just too much. Like, it's too much for anybody, for any judge in Massachusetts to just think about the simplest route here, the simplest pathway here. It's just too much to ask for.
The answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could...
That's not true. That's really, and that's really fucked up. Like again, there were verdicts on counts 1 and 3. 1 and 3 are done. They're no longer deliberating for count 1 and 3. They are done. The only one that is actually a mistrial is the only one they were hung on is count 2. And the defense is not even asking about count 2, guys. And nowhere in any of their filings to the Superior Court, Judge Bev, or to the Supreme Court, the Appellate Court, nowhere in any of their filings are they asking either court to do anything about count 2. They are only asking them to do something about count 1 and 3. Look at this judge. The judge the one that just spoke. He's like the jury deliberations were not done, and had they made up their minds on count 2, they might have changed their minds about count 1 and 3. Like, no, count 1 and 3 were done. Again, this is what the jury members have contended. This is what they keep saying, and they said it to the defense, they said it to the prosecution, they said it to Aidan Kearney, and Judge Beverly Cannoni herself considers their statements true and accurate. Why is this judge arguing in a circular way on something that was already deemed true and accurate by a Superior Court judge, Judge Bev? As corrupt as she is, she somehow still deems their verdicts on counts 1 and 3 true and accurate. Just unnecessary arguments. Just, why can't we just follow the ball? Why can't we just stick to the fucking ball? Just stick to it. Just follow it and play the game, this. All right, I'm sorry.
The subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannoni conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an external source. Right, but when it's
an extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not guilty?
So the question
Did you
asked
vote
to
not
juror
guilty?
F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two
The
things.
jury deliberations, right?
That would reflect that the voir dire.
Look at her smile. Like, look at her smile. Why is that necessary? It's not necessary, lady. It's not necessary to smile about this when the defendant to your right, her fate is hanging by a thin thread here. There's nothing to smile about. And no, it's not going into the jury deliberations. It's a simple fucking question. Was there a verdict on count 1? Was there a verdict on count 2? Was there a verdict on count 3? Before judge declared a mistrial, was there a verdict on any of the counts? What were those verdicts? It's that simple. It's that simple. There needn't be any additional questions after they provide the verdicts to each count. This judge must know Judge Beverly Cannoni. That smile is so inappropriate for what the hell's going on here. So inappropriate. And what is she doing? Like, I'm right? I'm right, aren't I? I'm right. You're gonna go into the jury deliberations, aren't ya? Like, fuck you. Like, what? Like, don't be a judge if you're gonna be like this.
By the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannoni, if conducted, that was my vote. It was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of jurisprudence that says we presume that the jury follows the instructions.
Okay. And there is cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The Caden
That's not
case.
this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity. And
before you shift back to that, what's the best case? That's federal case, because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? If we want to go back and read one case that's going to do what you want us to do, what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus State that the amici brief brought us to, where they read the newspaper.
It's a state court case, right?
Yes, it is.
Any federal cases? Because again, this is a federal constitutional issue.
You know, there are cases where jurors correct.
And if you guys remember the ACLUM amicus brief, the ACLUM provided case law from federal cases in which post-trial inquiries were permitted to occur. through the appellate court.
No federal case
This is,
that has the, you're asking us to direct Judge Cannoni to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
well, this court has a long history of applying
We don't
federal
have any
constitution.
cases except extraneous influence case. I'm just looking, again, your chance.
You do
Best
have-
case that we should look at for you.
You do have one example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
That's extraneous influence. That's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well,
This is
actually, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and
So the jurors submitted affidavits?
The jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again...
Exactly. Judge Beverly Cannoni considered them true and accurate. True and accurate. Why is every single judge on this panel ignoring that fact?
Let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules, Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether to...
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving the Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table? Is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So
Again, another judge putting the onus on the defense team. This is so improper, guys. It's so improper when the prosecution does it. It's improper when Judge Beverly Cannoni does it. And it's improper when multiple judges on this panel have done it. They continue to put the onus on the defense. They continue to say, you guys are intelligent. You guys are attorneys. You guys should have known that the Tui Rodriguez could have resulted in a mistrial. And it's the same argument that Judge Beverly Cannoni makes in her court filing. The defense wants to pretend that they didn't know that a mistrial was on the table. It's the same fucking argument. But again, it excludes any personal responsibility from Judge Bev. Where is her responsibility in this? What was she supposed to do?
Let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If Your Honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections. So
the judge...
Finally, right there, he is bringing forward his experience with the court process, with the system, and that when the judge is on a roll, you don't interrupt the judge. You are awaiting instruction from the judge. The jury were awaiting instructions from the judge. The defense is awaiting instruction from the judge, and so too is the prosecution. She declares a mistrial, and then either side are supposed to speak up after she declares a mistrial. They're supposed to say, wait, judge, wait. What of all judges, Judge Beverly Cannoni, the most unapproachable judge we've ever seen. All of these judges on the panel so far, or a majority of them, some of them have been quiet, but a majority of them have put the onus on the defense. That the defense had multiple opportunities to speak up, much like Judge Beverly Cannoni herself said in her filings, that the defense had multiple opportunities to speak up, when in fact there were 0 opportunities to speak up. You know, like, there's like the thin blue line when it comes to officers. There's clearly a thin blue line when it comes to these judges. These judges are defending Judge Bev. There is already a bias.
They're at an impasse. Bring in the jury.
Bring in the jury, and you can actually hear a door open.
Okay,
so
and you have 30 seconds to object.
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the jury.
You can't say, Your Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But they
the
did
note.
know that the jury had reported to her that they were at an impasse.
They were at an impasse. Bring the jury in. Yes, that was possible. But to
What was possible?
to ask to go to the bench, but
Yes.
this court...
And did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have this more of an obligation in double jeopardy law to raise...
Yeah, if you aren't catching what they're putting down, 3 of these judges have already made up their minds. 3 of these judges are going to deny the motion to dismiss. I'm just telling you that right now. They're not budging. Particularly the woman who spoke up last, and she smiled again. You couldn't have just called a sidebar. You did that throughout the trial, and she smiled again. She really thinks that the defense was like doing this all on purpose. She thinks that she, along with Judge Bev and the prosecution, believe that the defense strategically did not object to the mistrial, and that they're doing all this as some last-ditch effort to overturn the mistrial. All the while, they with the most power, the judges, the ones with the most power, from the Superior Court to the Supreme Court, the ones with the most power continue to ignore the jury.
Options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial.
After a careful consideration of all alternatives and after giving the defense...
May explain why, perhaps, the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted the verdict.
So, Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I contest...
But here the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Yes.
Right, in the face of that, do you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect, were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post-July 1, and I'm not arguing that that provides proof as to what the process was on July 1.
In the statute, again, is a may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, a number of notes, etc., and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry.
They really need to put Rule 27B up on a projection. You know, they need to read it line by line. These are attorneys. All of these people speaking, everyone in this image right here, they are all attorneys, and they all know damn well that it reads, the judge may declare a mistrial. And it applies to multiple counts. She may declare a mistrial, but she must first require that they return verdicts that they do agree on. Because there were multiple counts. It's not just one count. What is up with these judges? What is up with these attorneys? And I'm not referring to the Karen Reed defense team. It's like, guys, when judges in the Supreme Court don't know the rules of criminal procedure, we're fucked. This is why so many people get locked up in the U.S. for no reason. This is why the U.S. has consistently had the highest prison population in the world. This is why when lawyers decide what the rules mean themselves, it says the word may. It's not a requirement. It gives her, it says the word may, right? She may. It's like, what's the purpose of a fucking rule? And read the whole thing though. Read the whole thing though. God.
About partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence, where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
I will probably do a part 2 featuring the prosecution's, the Commonwealth's response, but we all know they're ultimately asking the Supreme Court to deny the defense's motion to dismiss. So we already know what the prosecution is asking, and they might trigger me all the more. So there may or may not be a part 2. We'll see. We will see. But so far, guys, I'm telling you, at least 3 of these judges have made up their minds. And by made up their minds, I mean they are likely going to deny the motion to dismiss. And there are 7 judges. I believe it's a majority vote here. We will see. We will see. But it's depressing when Supreme Court judges don't even understand the rules of criminal procedure. They don't even know why Rule 27B is there in the first place when there are multiple charges against a defendant. They don't even know why the words read may declare a mistrial, but must first require that the jury return verdicts on those that they do agree upon. When a Supreme Court judge doesn't get that language, that is why the U.S. has the highest prison system, the highest prison population in the world. When judges are permitted to interpret the rules and the laws how they want to, and when it is so clear that they are defending one another. Again, as if there is a thin blue line when it comes to judges. There is no hope for anyone in the state of Massachusetts if Karen Reed is retried. If the appellate court denies this motion to dismiss and Karen Reed is subjected to another trial in which she is yet again wrongly, maliciously accused of a crime she did not commit, there is no hope for anyone in Massachusetts. I've said it before, no one should be living here. Nobody should be paying taxes into this corrupt system where Supreme Court judges can't even read the rules of criminal procedure. I can't be optimistic, and I'm sorry. I'm sorry I can't be optimistic. This was rather deflating to observe. And simultaneously, I'm not that surprised. It's crazy how you're innocent until you're proven guilty, but not really. Not in the state of Massachusetts. If you're innocent in the state of Massachusetts, you got to work your ass off to prove that you're innocent. Even when there is compelling evidence that you are innocent. Even when the jury comes back after trial to tell the world that you were innocent. It's like, it doesn't matter what the evidence is. It doesn't matter what the jury members are saying. It matters how the judges choose to interpret the law. And it matters how the judges choose to defend one another. It's like, it's not a system to protect people. It's not a system to protect innocent. It's a system designed to protect itself. Isn't that some shit? These judges are speaking as if the rules and the system is more important than what the jury members have said, than what Judge Beverly Cannoni herself has said. They defend Judge Beverly Cannoni while they ignore her statement that the verdicts were true and accurate. Isn't that some shit? It is hell on earth, guys. It is hell on earth. And none of us are suffering as much as Karen Reed is. Imagine having some competent lawyers that have your back. One who came all the way from California to defend you. Imagine having a solid legal team. And imagine being exonerated. Through science. Through accident reconstruction. And imagine a Supreme Court judge smiling and chuckling while your fate hangs on the line. As if the defense team are just playing games. That's how these judges, not all of them, but that's how some of these judges treated the defense team, much like Judge Beverly Cannoni treated them. As if they were just playing games. And we know damn well that Judge Bev and her court filings muddied the water, putting the emphasis on the fact that the defense team didn't object to the mistrial, but they went out to talk to the press. And some of these judges on this panel mimicked her. They copied Judge Bev's arguments as if they read her court filings, but not the defense's court filings. You see how they are quicker to defend Judge Bev. They are quicker to defend a fellow judge than they are to seriously consider what the defense is asking for. They were not suspicious of Judge Bev's actions. They were suspicious of the defense's actions. It is hell on earth. It is hell on earth when Judge Bev doesn't look suspicious to the Supreme Court, but the defense does. I'll keep praying for Karen Reed. But it's really hard right now to be optimistic. Thank you for watching.